Hello.
Esteemed panelists, and our valued audience, both here and joining us via YouTube Live. A very warm welcome to everyone joining us today for this important panel discussion on the topic Strengthening the POSH Regulations Strategies for Ensuring the Safety and Empowerment of Women in the Workplace on the special occasion of International Day of the Girl Child. This event is organized by the National Judicial Reforms Council, a national level council and a non-profit organization under the aegis of the Women's Indian Chamber of Commerce and Industry. We kick-started our journey in 2021, and today we have 6 state and union territory councils formed under NJRC successfully running in the states of Maharashtra, Madhya Pradesh, Uttar Pradesh, Gujarat, Kerala, and the Union Territory of Delhi. Our mission goes beyond identifying shortcomings in the judicial system. We aim to bridge these gaps to ensure the swift delivery of justice. Over the past 3 years, we have organized numerous webinars, panel discussions, competitions, and awareness campaigns under the NJRC banner. Today, we are grateful to have with us distinguished speaker who will bring wealth of knowledge and expertise on this critical subject. As we know that the Prevention of Sexual Harassment POSH Act of 2013 was a significant step towards addressing sexual harassment at workplaces. However, a decade after its introduction, there remain challenges in the effective implementation. Today, we will explore how these regulations can be strengthened and discuss strategies for ensuring not only the safety but also the empowerment of women in professional environments. Before we proceed with the discussion, a quick note on logistics. Please feel free to post your questions in the chat box throughout the event. We will address them during the Q&A session towards the end. Kindly ensure that your microphones are muted during the discussion to avoid any disruptions. If you experience any technical issues, our support team is available via chat. Now, let me take the honor of introducing our esteemed panelist. Our panelist for the day is Dr. Devika Singh. Dr. Singh is a legal expert with over 20 years of post-qualification experience. She has acted as an external member in over 2,000 sexual harassment inquiries and is a recognized authority on workplace discrimination, diversity, maternity, and labor laws. She has also been involved in drafting key legislation, including the POSH Act in 2013 and the Maternity Benefit Amendment Act in 2017. Ma'am is the co-founder of Cohere Consultants, and she has worked extensively with organizations such as the UNDP and the Ministry of Women and Child Development. We are fortunate to have her expertise with us today. Following the introduction, now I take the honor of inviting Dr. Devika Singh ma'am to address our audience. Over to you, ma'am.
Thank you so much, Devanshi, for the kind introduction. I'm really grateful to the NJRC for this forum and, of course, for all the positive work that all of you are doing in terms of bringing out even more enlightenment and awareness, not only around this area of law, but also others. I'm also very glad that there are so many people present here with their interest around this area of law. I'm glad to see the participation and turnout that's there, and I thank everybody for your time. Okay. Now, today, of course, it's been put on me, the onus has been put on me to bring about something that is very close to my heart, which is a law on sexual harassment, which we've had since 2013 and completed a decade over, and now we are in our decade plus. I speak of this subject as something very close to my heart because I was on the first draft of this particular law and also on the penultimate draft of this particular law when I headed the National Mission for Empowerment of Women and was on the drafting committee for this law. A lot of the strengths that we have seen have turned into more strength over time, but a lot of the vulnerabilities that we knew even on the drafting table are now gazing at us, hoping that we will find solutions for them. So, for those of you who may be new to this topic area, I speak of the Sexual Harassment of Women at the Workplace Prevention, Prohibition and Redressal Act of 2013. This law has been there for a decade plus. It is there for women in workplaces. It picks up sexual harassment as a specific area and treats it as a civil offense in workplaces. So, understand for anybody who is new to this subject that though we do have a definition of sexual harassment in the BNS, that's the erstwhile IPC, that is with regard to criminal law, and here we are talking about sexual harassment at the workplace. Why was there such a gaping need for this law? We did see that women's participation in the labor workforce was struggling. All right. Even today, when we look at these indices, they are not the best, though the situation has certainly become better than the last time 10 years back, or maybe even 20 years back, and it was close to 11%, falling down, going up, and yet not really finding its feet. The law has brought about an equal platform for women to be able to come forward. Now, of course, as women have come into the workplace, as the new entrants, they have faced a lot of challenges. First, of course, in our country and on account of patriarchy, women largely are regarded as sexual beings, on account of which there is a lot of sexually determined behavior that would often be seen. This law, while it came out in 2013, has roots going back to a judgment in 1997 and incidents even much beyond that. All right. So, this is not a new problem that this law picked up, but it's certainly a problem that needed to be picked up. The law saw two sacrifices as we went along it. The first, of course, was Bhavri Devi, who was brutally gang raped and started the entire discussion around the law. And the next was Nirbhaya, which happened in 2012, which led eventually to the law coming about. As more and more women have joined the movement, we have come to realize that the law is something that is necessary and, in fact, game changing, not only for women, but even for other vulnerable groups. Presently, when I sit and look at trends that have come out in the law, over the course of the pandemic, the law has been able to help virtual workplaces or virtual working. We have been able to understand that sexual harassment doesn't just emanate from a touch, but in fact, sexual harassment can emanate from power. It can emanate also even from words. It can emanate from thoughts. It can emanate from sexism. These are new courses that the law has seen, and developing case law, particularly case laws that we've seen from the Supreme Court in recent years, has really helped galvanize the definition of sexual harassment and our understanding of the law itself. Another area that we rarely have seen the law emerge and come out is on the protection of vulnerable groups. While, of course, the law's starting point is the aggrieved woman, with the understanding that women themselves have an unequal footing in our society, the law has gone on to even provide protection to women who to trans persons who identify as women. It has also, in fact, been used by organizations to have gender inclusive policies that extend to all other sexes. So the law has started a conversation. But of course, with every step that we take forward, we do recognize that there are still a lot of steps that need to be taken as we move forward. When you talk about the key challenges, all the vulnerabilities of the law, I think what really comes out the most for all of us practitioners is the vulnerability of the aggrieved woman or the aggrieved person, if you would want to see a gender inclusive policy, and the vulnerability of an internal committee, and the vulnerability of process, which is principles of natural justice. I would like to talk about these three areas from the perspective of vulnerability because when I was a student, my doctorate topic, in fact, was vulnerability. And I realized that when we approach vulnerability through a constitutional lens, it no longer is an academic discussion. Even as a student, I saw that the constitution of our country is able to blow life into it. So let's just see these three areas that I spoke of. First, of course, the aggrieved woman. All right. The law certainly has certain shortcomings in terms of, well, ensuring that there is a timeline that has been put. That is a 3-month timeline which has been put on persons bringing up their concerns. There are pros and cons for this situation. The pro, of course, is that by putting a 3-month timeline, we are hoping that we create a situation where women speak up much earlier. And certainly, as we press on more awareness, on more training, that is a situation that is being achieved. However, one vulnerability that the law kind of misses is that a lot of times women speak up with great hesitation, and they speak up only after they feel they have escaped the power dictum that the law provides. What do I mean by that practically? Say someone is my boss, and I have a problem with this person because this person is sexually harassing me. I may not be able to speak up for as long as this person is my boss. I may find that I'm looking for a transfer, I'm looking for a change, and only when I'm able to effect that protection for myself, I'm able to speak up. By that time, 3 months may have passed by. The law certainly does provide a discretion to IC members to extend this period by another 3 months. But we have found that women wait till performance appraisals are over. They wait till they actually are able to find strength. Okay. They also wait with the psychological fears that they may be bearing. So, yes, this is certainly an area where the law has found some vulnerability. We have focused on how timelines can be extended. There was a bill also in the parliament early this year suggesting that a new timeline could be 1 year. All right. It's not a bill which has gone through, but it's certainly something that is being explored. This is one part of the vulnerability of the aggrieved woman. Once the process goes forward, okay, and of course, the law does have within its safeguards to ensure that a complaint may be made in writing, but will be reduced down to writing. Finally, the aggrieved woman has to be identified. That is a necessity. And I, as a practitioner, don't see anything wrong with it because we have to always consider principles of natural justice and the fact that there are two sides of a coin which have to come forward as we go along. So while anonymity is not something I think is a vulnerability of the law, that the law doesn't allow anonymous complaints, okay, But what I do feel is that one of the vulnerabilities of the law is the absence of specific measures for retaliation. Now, during the course of proceedings, we see retaliation in cases, and I have supported almost 3,500 plus cases. Okay, so we do certainly see opportunities for retaliation which don't just come from the respondent, that's the person who's complained against, but they also come from the system. All right, they come a lot of times from organizations, they come a lot of times from senior leaderships who don't want their organization to be associated with something like sexual harassment and feel like the aggrieved woman has opened a Pandora's box. We often do see that there is a huge focus on how confidentiality can be maintained, often to the detriment of the aggrieved woman. Clauses, NDA, etc., being employed, though the law doesn't prohibit. Sorry, Sri Hari, I think that you might have unmuted by mistake. Okay. Of course, if you want to ask a question, please. We certainly have the Q&A. Thank you so much. All right. Okay. So going back to what I was saying, retaliation is certainly a focus area that newer, okay, places in the law need to look at, newer versions and newer drafts of the law need to look at. Now, I've spoken of two areas for the aggrieved women. Believe me, there are plenty. But then I'm also very conscious that I have constraints of time and a very well versed panel member to follow after me. So now I'm going to speak about the vulnerability of the internal committee. Often we don't think of the vulnerability of the internal committee because we believe that the internal committee is like a quasi-judicial body. All right, we find that there are powers of a civil court that have been ostensibly given to the internal committee, and we feel that all is well. I have supported many panels, and I want to speak about why the law needs to talk about the vulnerability of the internal committee. Whenever there is a tribunal or an authority that is given any sort of power of a civil court or allowed to do any kind of, well, decision making or quasi judicial functioning, there is also a good faith protective when this panel, this authority, takes any sort of decisions, as long as the decisions have been taken in good faith, the members of the panel or the authority are protected from any forms of action. This is something that is missing from the Sexual Harassment Act. What it leads to is this. One, during the proceedings itself, if senior leadership were to be of an interfering nature and they were to find that the case is not going the way they think it should be going, all right, meaning maybe the IC is more proactive than necessary, we have seen transfers of members happening. Now, yes, case laws have, okay, tried to fill the gap by saying that members of a committee are akin and similar to powers, to as a judge would exercise powers and therefore should be protected. All right, so but that certainly is an area where the law should focus more. The other area is post proceedings. See, post proceedings, the internal committee is the most vulnerable because these are still members who are employees of a company along with an external member. All right, and once the panel stops its fact finding, they just become individuals who no longer have any power in that quorum. How is this misused? Often respondents who have not gotten, findings in their favor rush to the police, they rush to courts, they seek to implead internal committee members in various proceedings, they seek to start FIRs against internal committee members. All right, now all of this leads to a chilling effect because internal committee members then feel that maybe this was not a job they should have been doing in the first place. And you have to understand, the law depends on people who are sensitive, well-versed, well-educated, coming forward voluntarily in positions of senior leadership to act as internal committee members. This is a voluntary job, which of course they don't want any sort of commendation for, but certainly should be able to bank on the law's protection for. So this is another area where I feel that the law has vulnerabilities, and we should certainly look at strengthening this area of law. The third point that I speak about is principles of natural justice. Now, principles of natural justice, I'm sure all of you as academicians would well understand. Mainly, there are three. All right. There is the principle that is that no person will act as a judge in their own cause. Okay, there is all the ultra partem, give the other side a fair hearing. All right, and then there is also what we call, well, representation. Fine. So you've got all of this which is there. Now the third facet of principles of natural justice has actually been taken out by the law, because legal representations are not allowed in IC panels. All right, this is part of the rules. So largely what we're looking at is two areas. One, the IC should not be biased, should not be acting on its own cause, which is relatively easy to achieve. But the second is to give an opportunity or a fair hearing. This has got multiple interpretations. Multiple interpretations, because some would believe that this just means letting the other side know the materials that are relied on. Some believe that this means giving the other side a copy of all the materials. All right. Some would believe that this means that there needs to be cross examination. Some would say that no, cross examination may not be there, but there need to be questions that can be asked. All those interpretations are fine. But what is really, really important is that the IC is not a legally versed authority. So, one area of the law that really needs to focus down is possibly on building best practices. Certainly, we are not looking for regulations around process, because process has to be in accordance with the facts and circumstances of the case. You may be aware that in certain situations where there are girl students who have identified sexual harassment, say against a very senior officer in a university, all right, principles of natural justice by the Supreme Court and High Courts have expanded so far as to completely conceal their identity and not even have their statements being placed anywhere. So, when you have vulnerable situations like this, these regulations should be able to step forward to it. So, we are not looking for processes that are defined or set in stone, but we're certainly looking for SOPs or guidance around principles of natural justice. Because sometimes what happens is that when a case is decided upon by an IC and then moves to the appellate process or ends up going to any court of law, a lot of times there is a pushback from courts, despite the fact that the Supreme Court has said courts should not be hyper technical. All right, there is a pushback from courts in terms of why was this not provided or that not provided, without really understanding the intricacies, the sensitivities, and the vulnerabilities of the process. So I feel that this is certainly an area of law that needs to be looked at. Also, one major skip of the law, miss of the law, is not ensuring a quorum that has the external member on it. For those of you who may know, the internal committee is a creature which composes of at least 4 members. Of this, the external member is a member, okay, who mandatorily needs to be there in the constitution of the committee. Whether it is the internal committee or the local committee, the external member provides a lot of strength. However, if you were to see the rules under the Act, the quorum is only 3 members, in which the presiding officer is mandatory, but the external member is not mandatory. We have seen practices where organizations have paid lip service to having external members only on their panels, but not actually including them in proceedings. This is certainly a stumbling block, because the external member is the one who provides neutrality and transparency. And certainly we should be looking at this stumbling block being covered. So there you go. I have identified these 3 areas of vulnerabilities, okay, and spoken at length to the time that has been given to me. I hope I've given all of you food for thought. I know that as students, okay, this is something which, as a student, you should realize you always have that position of strength. Thinking you're just a student doesn't get someone anywhere. Understanding that you are an advocate, you are a person who can bring awareness, who can bring the distinction between the ignorant and the distinction between the person who has knowledge. That is the real strength of a student. The more you learn around these areas of law, the more you'll be able to extend your sensitivities to help not only your own transition from college to the workplace, but also bring your enhanced sensitivities to the newer workplaces that we are seeing. So I'm very grateful for your time, and I hope for your compassion as you go along and work and bring about more differences around you. Thank you.
Thank you so much, ma'am. Your speech was incredibly insightful and full of valuable information. Now I take the honor of introducing our second panelist, Ms. Divyanshi Singh. Prachi Pratap ma'am. Ms. Pratap is a seasoned advocate with over 10 years of experience representing clients in the Supreme Court of High Courts and various tribunals such as the National Green Tribunal and the National Company Law Appellate Tribunal. As a partner and Pratap & Co., a full-service law firm, she handles a wide range of legal matters. Ma'am has been recognized in the Forbes Legal Power List 2021 as one of the top 100 legal professionals in India. She is passionate about spreading legal awareness and promoting gender equity. We are honored to have her join us today. Over to you, ma'am.
Hi. Sorry for joining late. There was some issue, I think, in letting in the meeting. And first of all, thank you, Devanshi, for introducing me. And Devika, ma'am, it was so insightful to listen to you. It was so well explained. You know, I was thinking I will not be able to explain as beautifully as you have explained. So I'm just going to touch the latest judgments, definitely. But what ma'am has explained, I wish there were more, people doing these workshops, not just for employees, but people who are getting ready to get into industry, and have people like Devika ma'am explain so beautifully. I mean, I would like for more and more people that I know to hear her speak like that. It's very insightful, very well explained, which is so rare. And that is the biggest challenge with POSH that I feel is people don't know how to go about their rights. First thing is they don't have an idea of how to go about the labyrinth. They're so scared. If something happens, the first thing that I come across, and I'm not talking about that I come across in clients, I'm talking about people who just message me and ask is they're so scared to complain. They're afraid that they will lose their job, that it will tarnish their image, and they will not be able to get a job in future. So those issues are very pertinent, and that's why workshops like this are important for more and more people to know that first thing, the rights exist. Secondly, there are more people suffering, and it's not that one person is alone. In fact, I should not say it. Couple of years ago, a lady who was daughter-in-law of a very big businessman uh, had filed a case of POSH, and she was initially hesitant because there was no support for her from her family, even though the case was decided negatively. Uh, but it took a lot of courage for a woman coming from, so to say, a very broadened family mindset. Still, she found no support in filing a case about POSH, and there was also a gag order issued. So, such incidents happen, but they should not deter us. And Secondly, I'll just have a quick look at some of the important judgments that we have come across. One of the most important would be the Ola cab driver judgment. That caught a lot of limelight because Ola said that there was a sexual harassment case, and Ola said that the cab drivers are not their employees. And in fact, if we look at it, often Ola is drivers are not able to unite together because they do not come under unions and such things. So the case was where there was an incident of sexual harassment, and they said we will not be able to take action because these are not our employees. However, the division bench of Karnataka High Court held that there is an employer-employee relationship. So see, it is the interpretation of the law that it should establish the relationship, and that if that is established, they will be penalized under the POSH Act. So that is, of course, I'm sure it might further go into appeal, and maybe something bigger will come. And I hope something bigger leading judgment comes that is reportable, and it is a preceding judgment in such cases where there are a lot of companies that don't have that have contractual employees which do not fall under the category but can be interpreted that way. So the next interesting point that I was thinking of was implementation of the role of time boundness. We all know that every incident is always put in the category of time bar, but there was a judgment that came by Madras High Court where the incident of POSH happened in 2018, but complaint was made in 2022. So what happened there was, it was held that it was not just one single incident of sexual harassment. There was a continuous series of incidents that happened. So there it was held that it can be considered as a continuous crime. And when an incident of continuous crime or continuing crime happens, time bar will not be held. So we have to look at, there are a lot of things which do not fit in the law category. When we see that, okay, this is the law, it will not fit. But that is where it goes into appeal, and we realize that there is an interpretation and some leading judgment that might happen, right? So a similar thing that we have noticed since 2020, since COVID, since digital workplaces, we saw a lot of incidents, and Devika ma'am has also touched about POSH incidents when it comes to distance workspaces, digital nomads, digital workspaces. Is it maintainable or not? There was an incident where two questions were raised. First, the person was not working at the branch of the bank and she had complained about sexual harassment. Secondly, the question was if the message by the boss was sent after work hours. So the two questions that arose will digital workplace be considered for POSH? And if a message which is sent beyond work hours, will it be considered under POSH? And it was held, and I would just quickly pull up the act, because that I need to mention. Okay, I don't have the act with me anyhow. So it was held that digital workplace will be considered as workplace, because you see, banks have branches or companies have employees who are working digitally, and if some harassment happens sexually through digital mode, it will be considered as sexual harassment at workplace. Secondly, banking industry has these acts which allow that a person, a senior employee who's even working beyond the banking hours, that will again be considered sexual harassment. So that is a preceding judgment that is keeping in mind just a couple of facts. However, it will be considered. So we have considered time bar, we have considered employees that are not exactly employed by the company. Just a moment.
Let me explain something.
Sorry, I'm visiting my family, my husband and my daughter in US right now. So it's the morning scene going on. The daughter had to go for school, so apologies for the break. So there was another judgment that came by Calcutta High Court. It was about calling people by terms of endearment, darling, sweetie, all those words. So it was held that that will be under the Criminal Procedure Code, under IPC. It will be outraging the modesty of a woman, or it will be, colorful remarks will be considered under Section 354A of IPC. So that was again held as, sexual harassment. However, let me just clarify that later a judgment came by Calcutta High Court that said that not necessary that every time such words will be considered as sexual harassment. So it has to be seen in the context of the particular case. As I always say, every case has its own DNA. So we cannot say that one case it was held, so it will be held in every case. No, it depends on the particular circumstances of each and every case, the employer-employee relationship. So all that has to be established. And just quickly linking it with one more latest criminal law. I know it is not relevant to POSH, but since it is a latest criminal law, Section 69 of the Bharatiya Nyaya Sanhita, it talks about if a person promises to provide somebody a job or such employment benefits and then establishes a sexual relationship with a woman, that will be punishable offense. So this currently is not, of course, it's not linked with POSH, but this has been included in the new law. And I feel that people who are stepping into the industry need to know about this. So there was another question that was important, was same-sex harassment is maintainable under POSH Act or no? So it was held that there's nothing like this under the POSH Act, and it precludes same gender complaint of sexual harassment. And let's also be honest that POSH has excluded, as well as the new criminal laws have excluded, LGBTQ community and all of those from the benefits so far. And it is mostly favored and focused post Vishaka judgment, of course, on the women per se. However, there are a lot of other acts that work along with POSH which prevent the exploitation of women at workplaces. And when I say there are other acts, you have to always see that we are not only talking about POSH Act, but the acts that might be regulating a certain industry that may come into play. That is when I gave you the example of the banking industry. So when we're talking filing with internal committee, that is a quasi-judicial body, that's different. But when you're going into litigation, and also you're allowed to file a complaint in your organization as well as go ahead with an FIR. However, it is preferred that instead of burdening the courts and the police, we resolve it in the institute itself, in the organization itself. Having said that, it is important that you have enough evidence collected when you're filing the complaint. Of course, you're going through the internal committee and all that investigation is happening. But for any such case, ensure that you have enough evidence. And when I talk about enough evidence, make sure that you have screenshots, not just with the names, but deleting the names and with the numbers. That is extremely important. Keep chain of emails. Whatever evidence you can find. If you feel you have been harassed and you see there is a camera somewhere, immediately send an email to your organization and say that they can check the CCTV of that day. See, it is about acknowledging the incident, taking prompt action, ensuring there is a trail of evidence. These are important because later you might not remember the date, you might not remember the incident, and they might say that you did not bring it to the knowledge of the concerned authority. So these are important. I totally understand that we need to do a lot more to bring some tangible changes to the organizational setup, tangible changes to let more women get out and work there. Because once an incident of sexual harassment happens, I always notice that women will back out. There's so many who quit their jobs. And when we are talking about it, we're not just talking about women in private sector. People always think POSH, we're always talking about women in private sector. But let's look at the judges who gave up, who quit because of sexual harassment. So it is not limited to just a few. It is affecting more and more women need to come together to support each other for these complaints to be taken forward. And what happens mostly is, if one woman ignores, more and more women will suffer because it enables the person who's causing the issues. It will cause a series of victims to come forward because the accused is free to act at his own will. And that has to stop. And mind you, we have seen it in the recent cases that we heard of, the rape allegations in UK. That is again sexual harassment at workplace. So you are enabling a person by not complaining. And when one person enables, slowly and surely more and more people enable. So I will stop at this and maybe open the floor for more questions so that we can give some detailed answers and queries.
Thank you so much, Prachi ma'am, for your insights. It was actually a very well-rounded discussion, which included the interpretation of the law and some contemporary issues which have been arised. Apart from the POSH Act, we touched upon other allied regulations like CRPC, the Bharatiya Nyaya Sanhita, and the banking regulations which ma'am mentioned industry-wise. In the current social landscape, where safety of women in this professional setup remains a pressing issue, this discussion holds immense significance for all of us present here. We will now be opening the floor for questions from the participants who have been patiently waiting, and I'm sure they have a lot of questions for both of our speakers. I request all the participants to please type in the questions in the chat box so that we can begin with it now.
I'll also take the time while everyone is typing to thank Prachi for something which is very insightful and incisive. Okay. It's a mark of a good practitioner to absolutely be on call with all the case laws that are there. So, Prachi, I commend you. I think you've really added wealth to this forum by bringing on all of your knowledge.
Thank you, ma'am.
There are already some questions, Devanshi, Shika, some questions which are already there in the chat. Should we come up with them? Maybe, Prachi, if you could see a question that's of interest to you, you could probably pick that up and vice versa.
And for the convenience of both of you, I'll just read out the questions which have been pasted earlier.
Yes, certainly.
Sure. So one of the participants have asked that if there are any challenges which are faced to identify the genuine cases and the fake cases under the POSH regulations, as we can see that there are some fake cases as well. So the genuine cases are also sort of ignored. So in this case, what are the legal and the social measures which can be taken to address the issues of a lot of fake cases?
Prachi, is it okay if I go with this one?
Yes, ma'am, please.
And please, of course, feel free to add because this is a practitioner's perspective, really. All right. First, of course, I want to really bring out an understanding of how many fake cases there are, because we do tend to have a very enhanced view around the number of fake cases. Let's first understand something. All right. When a sexual harassment matter happens, it necessarily has to become confidential under the law, right? So, because of Section 16 of the law, it becomes confidential. Now, it is not available in the public gaze. Newspapers can't report about it. Media, if it does report about it, needs to ensure that there are abbreviations. There are specific safeguards in the law that cases, the facts, etc., cannot be put out. So, when is it that a case really comes in the public gaze? It comes in the public gaze only when, all right, say a case has been taken to the police, all right, or say a case has now, completely been closed down, it is reopened, etc. That's the only time it comes out. And this is not true. The one thing that we have understood as practitioners is that the Sexual Harassment Act works silently. All right. Because of confidentiality, let me tell you in terms of numbers, for every 100 cases that are genuine, there may be one case which is false. And I stand by this statistic because, as I said, I have by now, supported on almost 3,500 plus cases. All right. So first, we need to understand the numbers before we start talking about fake cases and the rising number of fake cases. Now, the other thing is that this is a law that brings out the perspective of the aggrieved woman. All right, where and this is a law which is groundbreaking in that sense because it is the perception that matters more than the intent. So this is a groundbreaking law. All right. Now, obviously, when somebody's perception doesn't match the other person's perception, then they will come out and say, oh, that's a fake perception. So a lot of the noise that we hear around the law is really that, okay, that, well, one person believes that this perception should count and another person believes that it should not. So do take your statistics of false cases with a pinch of salt is the first thing that I would say to all of you. Now, certainly, because of the fact that there is a strong pushback that happens, understand that this law is bringing change. And whenever any law or whenever anything is bringing change, there is bound to be pushback. Okay. And in that pushback, people are bound to make really generalized statements, which is something that we have seen happen to the PWDD Act also. All right, we have seen it with the transgender law, we have seen it with various other laws where vulnerable people are now coming forward and picking up their voice, okay, that there is a pushback. And one of those pushbacks, of course, is that this case is false. All right, so certainly In the minority of those cases, when something is proven false and it is given as much media outcry as often does happen, even genuine cases are approached by panels, by observers, with a lot of trepidation on whether there is genuineness in the case. We often find people asking questions right and the face of it, saying, is there a malicious motive? Could this possibly be false? Now, the law is unique in the sense that it has a provision on false complaints. It's unique because most other laws don't. All right. In its uniqueness, it has also brought out certain safeguards. For example, it has said that for false complaints, there needs to be an intent, a malicious intent which gets established. It also says that there will be a separate inquiry for false complaints. So these are safeguards. These very safeguards were questioned in a Delhi High Court case, all right, that happened some years back, fine, and this was the case of Anita Suresh. And in that case, the Delhi High Court, in its wisdom, imposed a fine of 50,000 rupees on the complainant, saying that this is a false case. Thankfully, the division bench stepped in and overturned that judgment because very clearly the judge had proceeded on the basis of no separate inquiry. So certainly we have seen pushback and corrections in terms of how this entire concept of false cases is used or misused. If all of you can take away that there are many genuine cases out there and our empathy should first start from that point, then we will do much better in terms of our understanding of sexual harassment. I know I've taken a little longer on this one question, but again, it's a question that's very close to my heart.
Thank you so much, ma'am. We understand this is actually a very important question. So moving ahead, we have a question from a participant, Alok. It's a very technical question here. Are the domestic workers and the women in informal sectors included in the definition of workplace?
Prachi, would you like to take that? I've taken quite a bit on the last one. Okay, just because I don't see Prachi turning.
I'll take that.
Go ahead.
So
Go ahead.
definitely domestic workers will be part of POSH Act. See, we said that it has to establish employer-employee relationships. So I'm not saying that this is how it used to be, but based upon how laws, when a law comes, it is like, a static thing that comes into play. But then all laws are dynamic and they keep changing depending upon the needs of the society. So definitely that part will be there. And also adding on to the previous question about the false cases, there are of course fines. And I also know of companies that have filed defamation suit once false cases have been pointed. However, I agree with Devika ma'am, there are very few false cases. Most of them are true. And in fact, I feel POSH is extremely underreported in organizations. If there was more and more reporting of POSH, we would have more women in workforce, honestly.
Thank you, ma'am. Moving ahead, we have a question with respect to the recent incident which happened in Kolkata, the RG case. So, where the participant has asked that such an incident which happened in a hospital. So, how can we ensure that in such a setting, POSH can be easily implemented and the safety of women can be ensured, as mentioned by the participant? But despite having multiple legislative forums, how can one ensure the efficiency of such established provisions?
See, I will refrain from commenting on this one right now because the matter is sub judice. It is going to be a reportable judgment. It is going to leave some important guidelines, but at this point, I will not comment on it because there's a lot of stuff that has been said on this. A lot of misinformation has been said, and I feel if I say anything, it can be misinterpreted. And when a matter is sub judice, it is not fair to comment on it as an authority.
That's definitely the sign of a responsible practitioner. I also would not want to comment on the specific facts of that case. I can, however, pick this up in an abstract manner. The abstract question that we should look at is that is it natural for organizations to go towards the Sexual Harassment Act when there is a crime that happens in, say, their premises or, say, in their extended workplace? All right. Now, one case that I'd certainly, because we have a judgment in it, and Prachi did pick it up earlier, is the Ola case. Let's think of, instead of a hospital, let's think of this as a taxi. Okay. We did see an act of molestation, all right, happen inside the taxi cab. While, of course, this was not physical molestation, it was an act where the taxi driver was watching pornographic videos and making best efforts to ensure that the passenger sees this, okay, and was masturbating in the presence of the passenger. There are several criminal offenses that open up right here. Now, certainly, this would have been a matter that should have gone to the courts. Okay, it should have been treated like that, which is why there was a police complaint. But what was the focus of the litigant? All right, was that this is also a matter under the Sexual Harassment Act, because for that cab driver, that taxi was the workplace, and for the woman who was the who was riding that cab, okay, this was also her workplace because she was on her way to work. So this is an extension of the workplace for both of them. All right. So she certainly has done all the measures that she has done to ensure that the Sexual Harassment Act does apply to it. So if you pick up this case just from that perspective, how can we ensure that, yes, there are multiple legislative forums? You may have a case that has dimensions of sexual harassment in the workplace, which is a civil offense. You may have a criminal offense also happening at the same time. I think to a large extent, what we need to understand is both these areas of law that can move in parallel without in any manner usurping the other's gaze. Okay, which means that I, as a person who is impacted, all right, can go and file an FIR and also at the same time go and move a sexual harassment complaint to the internal committee that is there. Here, internal committees need to be given more awareness around the fact that merely because there's a criminal case, they should not stop their process. And the police needs to be given more awareness that they do not take over a process which has been started under a civil law. So if we have more awareness and training around these areas of law, judgments are very clear. These are processes that can go on in parallel.
Thank you, ma'am, for your response, and we completely understand as to of a reserved opinion about a current ongoing issue. Moving ahead, ma'am, we have another question with respect to the POSH Act. A participant has asked that despite living in the 21st century, people still have a fear to file a case of sexual harassment, maybe because of social stigma or lack of family support, and as we say, victim shaming. So, in this regard, what social measures, can be taken to bring a social acceptance towards such law in our society and families?
I'll start this, and I'm sure Prachi would have a viewpoint to add around this. Okay. First, of course, the 21st century. Even if we think that we are living in the 21st century, we still have a dismal workforce participation rate of 23% of women in the workforce. So we may think a lot about the 21st century, but we still are oppressed. We still have patriarchy. We still have a rising trend of crimes against women. And certainly with all of this, it is very, very crucial for us to understand that people feel vulnerable. When I have discussions with women who are aggrieved, all right, a lot of times they come forward and then they say no, they now don't want to take it forward because their family might get to know. Often I've heard women even saying, what if this person were to throw acid on my face outside the workplace? All right, those kind of fears. And then, of course, the fear that how will they be viewed by their fellow colleagues? Will it be made out as if they made a mountain out of a molehill? Okay, as if they're oversensitive. It is a very difficult task for an aggrieved person to navigate the social stigma and also keep working. A lot of times, I can tell you, I've had young people who have just started working come and say, ma'am, we fought with our families to work. I never knew I'm going to get a boss like this. But now, if my family gets to know, they will tell me to come back home and get married. Okay. So there are many young people who fight social sexual harassment all alone. Now, what are the things that can be done to strengthen? First, of course, at least on the formal workplace, what has started happening, and I'm talking about white collar workplaces, I'm talking about your typical ITES companies, etc., and that industry. There is a lot of emphasis that has come on mental health now. And I think work life balance is also something that organizations are really now understanding. Toxic work environments, etc., are being spoken against. All right. So, young people, when they come and they raise a concern, they definitely are getting support from employee assistance programs, okay, and are able to maintain their mental health. The internal committee, because of the kind of forum it is also able to provide to a great degree counseling, comfort, etc. But what we really need to break down is the stigma attached to sex. And this is why I feel we are not in the 21st century. Okay? Because it is such a natural act, number one. And number two, it is not the only meaning of the word. Sex is not just the act of physical intimacy between people, and therefore is not just about sexual acts. Sex is about I'm a woman, you're a man, a person is of the third sex. Sex, sometimes conflated with gender, is about who we are. And if there are decisions that are being taken in the workplace on account of my sex, this has got nothing to do with my sexuality, me being a sexual being, etc. This has got to do with stereotypes. Society will truly change when we start normalizing sex and start understanding that there is no stigma against talking against sexism, sexist tropes, sexual stereotypes. Okay, the moment we take away that physical act of sex as a singular understanding of sexual harassment, our focus and minds will broaden.
Thank you so much, ma'am, for that answer. I think it brought us a very different perspective. I mean, even I learned a lot from that answer. With respect to that, I'll be taking the last question now due to the limited time we have. So the question here is that POSH Act is clearly focused on women versus men. What about different instances arising in the present scenario when not only women but non-binary and transgender persons, as well as men themselves, are subjected to sexual harassment at the workplace? Should the POSH Act extend itself?
That's a very personal question. Gender neutrality and transgender rights do not exist in POSH Act yet, but there are organizations that have taken this forward and brought it to knowledge. However, again, we are saying that we have not seen any development as far as rights for LGBTQ community or transgenders is concerned, even in the new criminal laws. So, if there was a change there, it could have been borrowed here. But having said that, anytime some violation happens, if it is reported, it might go into litigation eventually and come forward as a preceding judgment that may lead way or matter can be referred to center for consideration for making laws. Also, there was a point that I had to make was NCRB data suggested in 2022 that there were only 420 something cases of POSH. So that shows that it is so underreported. And what the previous question that ma'am was talking about, I would just add on to it. Um, Recently, 2 days ago, the UNICEF report came that said that 1 out of 8 girls before attaining the age of 18 suffers from sexual violence of some sort. So we make it normal, we make it hushed, we make it a stigma. And more women need to break the stigma for women to raise voices, for women to raise stronger women. So the issue is the dynamics of society does not change. We want women to be working, we want women to be empowered, but it is women who always go ahead, and I'm telling you this by experience only, women who go ahead and tell women, it's okay, this is how it happens. If you complain about this, others in the organization will also be affected. Sorry, that is what makes it an underreported crime. That is what makes it an ineffective act, and I'm telling you, it is an ineffective act. If an act is not being used and it does not bring forth social change, it is an ineffective act. And as far as men versus women question, which was there, see, right now, let's try to progress women by this. And eventually, when it comes to men versus women, we also know that domestic violence is one of the most abused acts. So for now, we need to, with POSH, we need to reach that balance where more women are able to freely join the workforce, and for that, women have to do more for empowering women. Acts exist, law exists, knowledge will for the law will also exist, but if more women are not going forward to support more women, none of it is going to happen. What will happen is ma'am and I and others will get messages in their DM from women saying, I need to do something, but there's a lot of pressure, there's a lot of stigma. I'll tell them, please go ahead. Ma'am will tell them, please go ahead. But again, the courage and confidence won't come because their peer group and their family group is not supporting. That support has to come from each and every one of us to get ahead.
There's someone who's in the chat who's put down men versus women rather than what's right versus wrong. And I really feel for this, for what this is, for what's being said. See, even Prachi is talking about this law as a starting point. We can only make a journey when we have a starting point. All right. I can tell you that this is not a men versus women issue. All right. This is an issue which is about power. Currently, yes, a particular sex, because of patriarchy, etc., has got more power. And now there is a need to cede that power. All right. When there is a need to cede that power, whether this was power held by women, by trans, by men, it is not relevant. The sex is not relevant. When people have to give up their power, then obviously they are going to resist. And what we are seeing right now is that resistance. Okay, and that is what is coming out in terms of the various harassing instances that people are bringing up. So certainly if we were to leave our conditioning of I'm a woman, I will stand for a woman, or why so women don't stand for women, or she's a woman, she will be against the man, or a man thinking, oh, they are women, they will be against me. If we leave that conditioning and just stay by what is right and what is wrong, what is egalitarian, what is something that advances liberty, what is something that advances rights and the exercise of rights and our consciousness, okay, we will be able to find more solidarity for each other. We will be able to find more empathy for each other. So I really hope that we can step beyond our gender, all right, okay, or the tropes that are created by gender, and we can think beyond that.
Thank you, ma'am. That's actually a point to make. Said we had a very wonderful Q&A session, which now comes to an end. So before we bring this panel discussion to a close, I would like to take a moment to express my deepest gratitude on behalf of the entire council. I would like to thank our esteemed speakers, Prachi ma'am and Devika ma'am, for gracing us with their presence and sharing their invaluable expertise and insights on this pressing issue. Your presence here today has been an inspiration to all of us, and we are immensely grateful for the in depth knowledge and passion that you brought to this discussion. We value your expertise in this field, which has enabled us as students to gain a deeper understanding of the legal aspects and gain perspectives about the current implementations of the POSH regulations. I would also like to thank all the council members of the National Judicial Reforms Council who worked hard to make this event a success. We further thank our audience for the support and active participation throughout this discussion. Your engagement has been instrumental for us today. It is a sincere request to all the participants to please fill in the feedback form, which is mandatory for the successful generation of the letter of participation. You can find the feedback form in the chat box. Thank you so much, everyone, for joining in today. Happy learning. Thank you, ma'am.
Thank you so much. Thank you, ma'am.
Thank you so much. Thanks, Prachi. Thanks, Shloka. Thanks, Devanshi. Okay, and of course, thank you to the NJRC for organizing this and everyone who's attended. Thank you.
Thank you so much.
Thank you, ma'am.